everyone is not easy. I remember in Rukmani's Swayamvaram, there says, Kunjan Nambiar says, Uttangudadulla Naranmar, Urayum Bhumil Ennuda Tada, Leksham Manushar Kudumbol Adil, Lekshana Mottavar, Onno Rando. So the point is, when we are going to find out this Lekshana Mottavar for our justice delivery process, then the system of N.J.A.C better serves the purpose. Thank you.
My task is to summarize what's just gone ahead and to give my perspective. But kindly remember, they may have used very powerful language, argued and tried to persuade us to their best ability, but they aren't their personal opinions. As advocates, you all know, our argument depends on the case of our client, not on the strength of the truth. So, at best they have played the devil's advocacy. And may I say one thing before I could give my summary. As you're all, they too are very busy advocates. They have spared time, they prepared well, they have articulated very well, and they have entertained us and also they have enlightened us. Why not give them a big round of applause? Now, I'll have the task of just putting the whole thing in perspective. The proceedings have begun with the senior counsel, Srimati Sumati Dandapani. She has first spoken about the constitutional conventions. Then she has taken us through the second judge's case and also briefly touched upon the N.J.A.C. And eventually she has illustrated a very recent incident about what somebody could call the executive interference in the judicial affairs that are Bangalore or Karnataka issue. Then came from the same side, without switching, I could as well continue the tone of their rather submissions or arguments. Dr. Tushara James has said that it's a matter of power struggle. When it comes to appointing judges to the Constitutional Court, she has felt that the powers they wield are enormous and an error of whatever magnitude is extremely dangerous. Then she has said that the experience we have had is very bitter and the experience is the best teacher. Then she has referred profusely to all 1, 2, 3 judges' cases, 81, 93, 98, of course with the tinge of political backdrop. Then she has said that N.J.A.C is not part of the original intent. What she meant was that when it comes to interpreting statutes, and especially the Constitution, which is an organic instrument, you had two methods. One is that of original intent or the doctrine of originality, where the words have to be interpreted based on the meaning they carried at the time of the framers employed them, at the time of the constitutional debates perhaps. And the other school is that of dynamic interpretation, where the word has to be used in the context as has been prevalent at the time they fell for consideration. She has said that it's not been there at any point in time, that's why they're clamoring for N.J.A.C may not make any sense. Then her point is with regard to the decision, what we could call the recent 4 judges case, and eventually she has said that any attempt on the part of the executive to bring in legislation in the name of N.J.A.C would be opposed to the doctrine of separation of powers. And finally, the turn of Advocate Srimati Parvati Sanjay, she has said that first she has put the issue in a historic perspective. Then she said, if at all those days, at least until 1993, there were appointments by the executive and not much amiss had happened by then, she felt that because then there were statesmen rather than politicians, you could read perhaps between the lines what we have presently. Then she has gone to say that when it comes to collegium, well, there may not be any particular expression of that system in the Constitution. According to her, the letter of the Constitution may not have spelled it out in so many words, but the spirit does indicate that it ought to be an independent process. And she feels that collegium could be an ensuring factor of transparency. She has also said that N.J.A.C has been riddled with defects. She has said that two laypersons, without further description about their qualifications, they could be termed laypersons, and they have been given the veto power. To what extent they could have such powerful veto in their hands and still employ that, if at all, not for a nefarious purpose. That's what she has said. Then the legislation that's been struck down, according to her rightly, by the Supreme Court has never represented or reflected the will of the people. And finally, she touched upon the reciprocity or quid pro quo, if at all there is any nexus between the judiciary and the executive in their collective role in appointing the judges. She says that it amounts to you scratch my back and I'll scratch yours. She says it is anathema, antithetical, and it cannot be countenanced. That's how they have come to a conclusion that it's quite essential that the judiciary must maintain its independence, and nation is not prepared to have an appointing agency that could have executive as its co-functionary. They have felt that the system that's been there in place is right and it should be continued. Then came the counter arguments by the other panel with equal eminence, vehemence and conviction. They have said, beginning with Senior Advocate Sri M.R. Rajendra Nair, he has first said the morphing of judicial interpretation and the mutilation of English language, that's the consent or the consultation. He has felt that an innocuous term consultation has been morphed into a legislative mandate, that of consent. Then he has said that if that be the case, and the primacy, the opinion of the Chief Justice of India could have that much of primacy, how about the other constitutional functionaries who have got an equal role to play? To illustrate, he has talked about the governor. Should we have the same primacy given, is his rhetorical question on that aspect. And also he said that the very constitution, the preamble begins with, we the people. If the people are the persons, they decide the destiny of this nation, can they be separated and kept out of this vital process of electing to the constitutional posts? That's what his anguish on that point is. Then he has also said that, if at all, it's a basic feature, because they felt that those proponents who have been supporting the collegium system have been telling that judicial independence is a basic feature. Then similarly, even judicial review is a basic feature, an appointment, inscrutable, opaque system, and then nobody could challenge that. Though it is not a judicial function on the part of the court, a mere administrative function discharged by them, but still they have denied a judicial review, which is equally a basic feature, is his argument. Then comes finally, they have said that if at all the appointments have to be fair and free, the courts that have already been overburdened, especially the judges, should be freed of this responsibility, and wide consultation, especially by the executive, is essentially his opinion. Then came the turn of Dr. Jacob P. Alex. He has said that Constitution has absolutely in uncertain terms, very definitively, has given primacy to the executive. Then he said, when it comes to the constitutional debates, having profusely referred to eminent personalities like Dr. Ambedkar, he has felt that they have said that despotism, even in the name of democracy, cannot be countenanced, and giving power entrusted to even the Chief Justice of India as a single person to appoint judges could spell doom for democracy, is his opinion. Then he has referred to all the judges' cases, as the other candidates have done, contestants have done. Then he has pointed out 5 major defects the collegium system has suffered. He has said that it has no constitutional basis, and the system is rather opaque, and no criteria for elevation, and the very system is anti-democratic, and nobody could question any selection, even if they could have very cogent reason for that. In other words, he has carried his partner's point of view that judicial review has been denied. Then he has referred to comparative jurisprudence of other nations. He has said that USA has a distinct method, as you could see from Article 2, Section 3, There the President does appoint in consultation with the Senate. With Senate, then he has referred to various other nations including Russia, France, Canada, Italy. Then came the turn of Sri Shyam Kumar. He has said that the N.J.A.C composition has been attacked by the other side, in his view, because a couple of persons may not have legal background. He has said that the very system exists for the common man, and two of them drawn from the public life ought to be there because they've been supported by the other eminent personalities as well. Then he has said that at the time when the case was going on, one of the counsellors pointed out the public perception and has used the burqa analogy for that one. Then he has also said that while throwing out the legislation, the Supreme Court ought to have been more circumspect because it's a golden opportunity that's gone a-begging, is his opinion. Then also he has attacked frontally the view held by the other team that when it's been a political struggle, whenever the center is strong, it has tried to put his hand on the upper side, and that's been reversed whenever Supreme Court could get an opportunity. And he has said that is it a sin or a wrong in a political system to have strong governments? He has said that that's the need of the hour so that they could have the legislative mandate to bring in the whatever reforms they would like to. Then he has also said that if at all judicial independence is not negotiable, at best there's only one factor, one facet of the entire judicial system. It cannot override or obliterate all other systems. Then he said separation of powers. When it comes to separation of powers, there is no watertight division. These are the submissions, rather points that have been very powerfully urged on either side. My friends, to close the proceedings, I may say one thing about the whole issue. Constitution is always cryptic. It is not an ordinary legislation where you will have every provision in detail, though ours is very prolix, perhaps the longest in the world. But still, when compared with any legislative device, it is very cryptic and the shortest possible. So, there are silences and in-between readings of the Constitution. You take the example of Article 14, it does have one single sentence. You take Article 21, it does have one single sentence. But they have generated enormous jurisprudence. So when you read, be it 124, 217, they've been very cryptic. But you would have seen so many judicial minds have engaged their attention. And still they could not come to a definitive conclusion. And you know, our Constitution, we have had the advantage of hindsight. Hindsight in the sense, by then many constitutions have come into existence. Prominently the American and the unwritten experiment in benign monarchy of the English. Then other countries like Canada, because it's a federal concept, Australia. Then you have got other host of countries including the Dutch, the German, though it's civil jurisdiction. All these countries who have had an eclectic form of constitution, drawn all the features from various things. I believe when it comes to appointing judges, we could not have the model adopted from the English system, though we have had the bicameral system of Parliament, because they have had the hereditary appointment of House of Lords, which is impermissible in a democracy. Then I believe they have gone for the system that's been then invoked by the Netherlands. They have taken the system where the executive appoints in consultation with the Chief Justice. Then it has undergone. But you see, when it comes to all the nations, there are any number of systems of appointing judges. No system could be said to be a perfect system. For example, if at all we want to follow the closest system possible to us, could be, to some extent in a federal setup, America. You take when the Supreme Court was formed in about 1787, then it was a toothless tiger. It didn't have even a permanent building. And they were appointed. Even the very ministers who were serving in the government of Adams was appointed the Chief Justice of the Supreme Court. In fact, Chief Justice John Marshall was a minister in Adams' government. And he was the law minister at that. Then, he did not serve the warrant on the judges who have been appointed. They are called midnight judges. Because Adams' government lost power, it was on the way out. While going out, they wanted to appoint judges en bloc to the circuit. That means the intermediary system in federal system on a par with high courts in America. Then overnight, they prepared all the warrants. They have sent to them. Some have remained. They could not be served. By then, the new government took over. Then they tried to serve them. That government rejected. Then the person, Marbury, one of the judges that missed the appointment, filed that Marbury v. Madison. The man who did not serve the warrant as a minister then was the Chief Justice. He heard his own case. And he was the cousin of Thomas Jefferson, then the president. They had a lot of rivalry. He gave a judgment, giving us, for the world, first time, the power of judicial review. And he pretty well knew, if he says government should appoint, the very Supreme Court will disappear. Thomas Jefferson has already warned him. If you trifle with my power, it's a nascent democracy. 1803. He said that if you trifle with my power, I'll finish you off. You know what he did? He laid down every rule of judicial review. In the end, he said, we have no jurisdiction. Because American Supreme Court does not have original jurisdiction. And mind you, one more factor, American Constitution has no qualification for a judge to be appointed. And for that matter, the greatest Chief Justice for 35 years, Chief Justice John Marshall, had no law degree. Then afterwards, 2 more judges had no law degree. But that system to this day has been perfectly functioning. And the judges will be appointed based on their political leanings. Whenever there is an issue decided, legal experts will discuss the issue across the country, not based on the legal principles. How many have been appointed by the Republicans and how many have been appointed by the Democrats? But the system has still been going on. You know what happened in England? England had a monarchical democracy, if you could call it. Then they had life peerage, where law lords could be doing it. The very law minister is also the chief law lord, and also he is the Speaker of the Second House. Still, they had a perfect system until recently, up to 2005. They thought that they should free the appointment of judges from judicial interference. You may kindly see, in 2005, they have brought a legislation. That's Constitutional Reforms Act, CRA 2005. After that, that was put for debate, and you see what the Prime Minister of this country told in the Parliament about the powers the executive enjoys. I'm not taking stance. As a historic fact, I'm telling that. Please kindly listen to it. For centuries, the executive have exercised authority in the name of the monarchy without the people and their elected representatives being consulted. So I now propose that in 12 important areas of our national life, the Prime Minister and the executive should surrender or limit their powers, the exclusive exercise of which by the government of the day should have no place in modern democracy. Now comes the final coup de grace, the kind blow.